Good morning, everyone. Welcome to House Judiciary. Pierre, you want to call the roll?
Representative Brady.
Here.
Representative Breton.
Almost here.
Here. Representative Chestek.
Here.
Representative Filer.
Is excused.
Representative Kelly.
Here.
Representative Lean.
Here.
Representative Singh.
Here.
Representative Webb.
Here.
Chairman Washut.
Here.
You have a quorum.
Thank you. Our first bill for this morning is House Bill 166. Representative Bratton, welcome. Why don't you walk us through the bill?
Thank you, Mr. Chairman. And thank you to the committee for hearing this House bill. My name is Laurie Bratton. I'm the representative for House District 51 in Sheridan. I'm here to introduce House Bill 166, State Auditor Payment Transparency. The purpose of this bill is to codify the terrific work that our state auditor is already doing through the website wyopen.gov. This website provides valuable service to the people of Wyoming, transparency for taxpayers, cost savings for the Department of Audit by reducing public records access requests because the payment data is already posted online. wyopen.gov is Wyoming's online checkbook. It gives public easy access to the state of Wyoming's expenditures so people can see how the state spends our money. This site includes data for expenditures made by the state of Wyoming for the past 5 years. Although this work of transparency is in place today, it is not required by state statute. This is a project that the Department of Audit has put together on its own accord. But a future state auditor could decide to not continue providing this service. House Bill 166 would simply codify the work that the office has already been doing so that the people of Wyoming won't lose this valuable resource in the future. The Wyopen website publishes payments made by the state of Wyoming through Wyoming Online Financial System, WOLFS. It publishes payments made to vendors for the purchase of goods and services. But while the data is very comprehensive, it doesn't include all of the state of Wyoming expenditures. That's because confidential or sensitive data, which is protected by state or federal law, has been excluded. Information that is excluded would include, but is not limited to, transactions that qualified as aids to individuals such as Medicaid and Medicare and other direct assistance payments, refunds associated with assistance programs, expenses related to confidential law enforcement activities, subsidized adoptions and/or foster care payments, and child support recovery, collections, distributions, and refunds. Also, victims' compensation claims, personnel, and disability claims would not be included. The expenditure data is classified by types within the WOLF system, and the data can be searched online and downloaded into a spreadsheet. That data includes date of payment, state agency making the payment, the vendor that the payment was sent to, an expenditure category, a description, the amount of the payment, as well as other data entry codes such as invoice numbers. Yesterday, I went online and downloaded all the available data for the month of this January to date, and that data included over 96,000 transactions, ranging in size from 1 penny to tens of millions of dollars. People can search for the data online, or they can download the data onto a spreadsheet. So with that as a backdrop, let me walk you through the bill. So the state auditor's duties are in 9-1-403. And this bill on page 2 creates a new paragraph, Romanet 9, which starts on page 2, line 2. The first several words on line 2 are very important, subject to state and federal law. This is important because this ensures that sensitive or confidential information would be protected under existing legal frameworks. Given that protection, it goes on to say that the office shall make all payments made by the office available for public inspection and download. It goes on to state that the minimum amount of information to be posted in an allowable lag time of 30 days from the transaction to publishing date. As I mentioned earlier, data posted on Why Open today, it currently runs about 2 to 3 days behind real-time payment, but that's only 1/10 of the time allowed by this bill to post transactions. Finally, the bill states that the information posted shall be maintained on the website for at least 5 years. And that is the bill. I stand for questions. Thank you.
Committee, any questions? Representative Kelly.
Thank you, Mr. Chairman. So just to sum it up, the state auditor is already doing this. We decided it was a good idea, so we'd like to future state auditors to do it too.
That is correct, Mr. Chairman.
Further questions? Thank you. I see you have some friends in the room.
I do. Could I bring up the state
Please.
auditor, Christy Rosinas? Thank you.
Madam Auditor, it's always wonderful to have you come to House Judiciary.
Mr. Chairman, it's been a few years since I've been to Judiciary. Christy Rosinas, I'm the current state auditor. Thank you so much for considering this bill. I'll be somewhat brief, but give a little bit of history. When I came into the office was under an active lawsuit for not turning over, the request at the time was 5 years worth of spending data. So that was an issue that was right in our face, right off the bat, and we wanted to get that taken care of. We did get those records turned over and the lawsuit dismissed. However, we thought at the time that really folks shouldn't have to sue the government in order to get the data, so we wanted to be a little more proactive. And I can't talk about this bill without giving huge credit to the IT folks in my office, but one in particular, Christian Dorr. Basically, this was his baby with help from other staff. He came up with this idea to essentially put this website up at almost no cost to the state, and I'll talk about that in a little bit. Over the last 5.5 years, we've worked to improve the site. We are always open to feedback if there's more or less people want to see. It's not perfect. It's not $1 million solution like some other states have, but it's a really, really effective tool to put out a lot of public information that's accessible, really with very little effort. We have seen a reduction in public records requests relating to expenditures, but I think even more importantly, what'll happen is folks will go to this website and then bring us a request that's a lot more fully baked. It saves both my office, but also other state agencies time on public records because a request is going to be a lot more refined by the time it gets to us. Total cost to maintain the site, and these numbers are a year old, but I don't think it's changed much. It's running about $1,600 to $1,700 a year. Most of that is just fees to enterprise technology services for the server space. And the very most difficult part of getting this project done was getting a .gov website. It's like, I always joke, I think President Trump at the time had to bless it with his little finger to get that .gov designation. So, stuff like that's $400 a year and some of the other domain names. So really, really minimal cost to the state. With that, Mr. Chairman, I know you have lots of work to do, but I'm happy to answer any questions or concerns.
Committee, this may be your one chance to ask the auditor questions, so any? I'd just like to say thank you for doing this. It really was a breath of fresh air when you arrived and took care of this.
Thank you.
you.
And again, Mr. Chairman, we're always looking for feedback. So if there's something that folks think we could do better, we love to hear about it. So,
Representative Webb.
And I would echo, thank you. I would echo the good chairman's comments, and I would also add, thank you for doing it so economically, because I think that could be inflated very easily, and I appreciate you being cognizant of the funds.
Mr. Chairman, I will add one final kind of cool statistic about why this is important and kind of the saving of public public records time and effort on behalf of state employees. When we put this website out there, everybody, said, oh, great job, how wonderful, blah, 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 blah. And then, like 3 people went to the site. I'm exaggerating a little bit, but the hits to the actual website were fine, but not remarkable. And then a year into that, about a year and a half, we started sending out COVID dollars, and hits to the website went from about 1,000 a month to 20,000 in, I think it was November of 2020. So it got even more relevant real quick and somewhat unexpectedly when specific projects or specific endeavors came through the state.
Thank you for adding that. Representative Vice Chair Singh.
Thank you, Mr. Chairman, and Auditor Racines, thank you for being here today. Can you talk to us a little bit about the timeline that it took to build up this website and the cost associated with it?
Madam Auditor.
Mr. Chairman, Representative Singh, sure. So I came into office in January of 2019. I believe we launched this in July of 2019. At that point, why did it take 6 months? So there's the technology end of, and of course that is not my expertise. And again, I would throw all of that praise on to my employee that I referenced before. The trickiest part was going through the chart of expenditures or the chart of accounts for the state. So essentially every expense, every payment the state makes gets coded a certain way based on what type of expenditure it is. This is one example, your travel reimbursement for a legislative meeting, your per diem would go to one code, your car expense would go to another code, and your hotel expense might go to a third code. And there are thousands of those codes throughout the state. So we worked with agency heads and our Attorney General's office to go through all those codes and make sure we were pulling out anything that was confidential. So we walked that a little slowly at first, because once you can always put more information out there, but once it's out there, it's hard to pull it back if it was something you weren't supposed to release. So when we first rolled out the website, we had a 30-day lag, and we actually visually put our eyes on the payments just to eyeball it and make sure we weren't releasing anything. 5 years on, we've gone to daily. So you should be able to go out there and look at what was paid yesterday. The cost, it's a little less than $1,000 a year for the server space at ETS. The .gov registration is about $400 a year. And then there's an SSL certificate that's $30 a month. And then, of course, when you own a domain name like yo.gov, it's also important to own the .com and the .net and the .org. So we do that as well for very minimal expense, so that somebody else can't buy those and then try to, sell them back to you for a greatly inflated price.
Follow up.
Thank you, Mr. Chairman. Madam Auditor, do you have any additional features that you anticipate adding to the website?
Madam Auditor.
Mr. Chairman, Representative Singh, the sky's the limit. Right now, we've tried to hit a balance with not flooding the site with information, because what we've found, if you put absolutely, so an expenditure line, and these are listed out in the bill, we put agency, amount, date, category. There's about 30 other components of that expenditure line item that get coded into the system. If anybody comes and asks me for those budget string questions, of course I would be obligated to turn that over. We're trying to hit a balance. I can dump all of that information online. At that point, it becomes almost not useful because it's too much. Your average person going out there and downloading it into an Excel spreadsheet, it becomes gibberish. And not insulting anybody's intelligence, just it's a, unless you know what all of those things mean, it becomes sort of not useful.
Representative Chestic.
Thank you, Mr. Chairman. Thank you, Madam Secretary, Madam Auditor. I love this. I think you're doing a great job, and I think it's very important to have transparency. I'm always looking for whether there's any any ambiguities in the statute. And I think line 6, I think it works, but I'm just trying to think if there's anything that we haven't thought of yet. So I understand that we're not releasing any salary information or personnel information, things like that. And I think line 6 excludes that. Vendors for items furnished or services rendered. It's the services rendered that I'm just trying to think, and I can't think of one, so maybe it's fine the way it is. Is there any kind of service rendered that would be confidential, that would be covered by this, but you shouldn't release? I guess that's the only words that I'm thinking about. And again, I'm not opposed to this because I haven't thought of a problem, but are there services rendered that should be held confidential that might be captured by that word?
Madam Auditor.
Mr. Chairman, Representative Chestek, yes, I believe there is, but those are protected again by their expenditure coding. For example, and I'm not sure that this would qualify as a service rendered, but like a payment, like a lot of victim services payments, or potentially sometimes, and I'm getting into the weeds a little bit here, but I think you'll appreciate this, payment to an expert witness while the case is still going on. Additionally, Mr. Chairman, and again, those are very unique situations that don't happen very often, but that's where working with all the different sensitive agencies also have the ability in certain codes, and the expert witness is one of them, to tag an expenditure as restricted so that it will not show. And again, I want to say, if we ever get a public records request apart from this, we respond to those and would delve in even further on some of that information. But it's a great question. We've tried to cast a wide net, but also be pretty cautious. Because again, it's harder to take back once it's out there.
Very good. Further questions? Thank you very much for being here this morning.
Thank you.
Anybody else in the room wishing to testify on 166? Please step forward. Good morning, Representative.
Good morning, Chairman and members of the Judiciary Committee. This is such an exciting
Please
site.
state your name for the record.
Oh, I'm sorry. Steve Johnson, House District 8. And we have been using this site to see where Wyoming's money is being spent. And it's a totally explorable spreadsheet. You can ask questions to it. You can find out what's the favorite beef producer that the state of Wyoming uses to feed their prisoners or whatever they use it for. I mean, it's unlimited what knowledge you can gain from that. So it's a very useful website. We use it, quite often. So.
Questions? No? Thank you for coming this morning.
Thank you.
Good morning. State your name for the record and then tell us what you want us to hear.
Morning, Mr. Chairman, members of the committee. My name is Kevin Lewis. I reside in Laramie County, Wyoming. Back before Auditor Racines was elected for the first time, I was a board member of Equality State Taxpayers. And we, along with American Transparency, sued the state auditor over the checkbook. It resulted in about 9 months of litigation. It was expensive for the organizations. It was expensive for the state. I congratulate Auditor Racines for correcting that situation and putting this online, saving all kinds of money for both the public and for the legislature in the state of Wyoming. So we'd rather not do that again. So this is mortar to the bricks of the foundation for transparency, having this law make it required to have the website. And I appreciate all the work she's done. I've watched refinements happen on the site over the years, and she continues to maintain that website very well.
Very good, thank you. Questions? Representative Brady.
Thank you, Chairman. I'm not sure whom to ask. I so trust what's going up now, but if our current auditor ever left, is there a way we can check to make sure that that high standard is maintained for the website?
If I can, Mr. Chairman. Mr. Chairman, Representative Brady, I use that website an enormous amount. I've trained dozens of legislators to use the website and tens of people in the state and in other organizations how to use that site. I'm on it all the time. I see if there's any problems, and I've communicated with her office. She has been exceptionally responsive to keep things going well. If I see any problems, I'll report them to her. I do ask for public records requests from her on things outside of that system, and I've never had a problem getting anything from her.
Follow up?
Yes. So I guess my point is 100% I love the website right now. And if we keep our current auditor forever and ever, that would be awesome. But if not, then you can report to someone to say, you know, the standards have gone down and need to be, or who would watch that?
Well, absolutely, it's.
To the chair.
It is.
Through the chair, please.
Oh, I apologize, Mr. Chairman, Representative Brady. Absolutely, as long as I haven't perished from the earth, I'll keep a watch on it. And it's a collaboration between government and the citizens. That's what transparency is. So long as people are looking, I think they will report it if there's a problem.
Further questions? Yeah, thank you very much. Anyone else in the room wishing to testify on 166? Anybody on Zoom? Going to close public comment. Committee, what's your pleasure? Move the bill by Kelly, second by Webb. Discussion on the bill or amendments? Representative Chestic.
Thank you, Mr. Chairman. I have a clarifying amendment, I think, to try and strengthen the bill. I'm in favor of the bill. I'm going to vote for it. I'm a little, again, I apologize for putting us all into the weeds here, but this is the legal writing professor in me coming out again. On line 2, page 2, line 2, subject to bothers me. And here's why it bothers me. Subject to state or federal law, and federal law. This is a state law. So it's kind of a circular thing. Subject to this law, which makes things open. The point of this subject to is to say there are certain things that need to be held back. This bill makes them come open. So in its state law that is incorporated by subject to state law, I think the clarifying to get to the intent of this, I'd just like to change subject to read unless otherwise prohibited by state or federal law. I think that expresses the intent to where state or federal law requires you to hold things back. That's gonna be primary. Everything else is disclosed. So I think it clarifies and is consistent with the intent of what you're trying to do here. So that's my motion.
Is there a second to the motion? I'll second it for discussion. Representative Webb, you look like you're wanting to say something?
I don't see any, where that would make a drastic change in that. I would like to have some discussion if somebody sees it differently.
Further discussion? Representative Brady?
Can we, may we ask, thank you, Chairman, may we ask the advice of how would that way affect the bill, or if they're in agreement?
Representative Bratton?
I did work, Mr. Chairman and Representative Chestick, I did work with all the lawyers in our Legislative Services Office on this, and they helped craft this language. So if the auditor is all right with it, I'm all right with it. I wonder if you'd want to hold that off to maybe a second reading and go into the Legislative Services Office and ask those questions. I'm not a lawyer, so I don't know precisely how that would impact, if that would impact this bill, or indeed if it would make it better.
Further discussion? Representative Chester?
I'm happy to talk with also lawyers about it. I do think this is clearer, but I'll be happy to, I can bring this as a committee of the whole amendment after I chat with LSO.
Are you withdrawing?
I can withdraw it, yes.
Amendment's been withdrawn. Further amendments? Further discussion?
That'd have to go through the second.
I seconded it.
Oh, okay, sorry.
Yeah. Further discussion? Further amendments? Seeing none? Call the roll on 166.
Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestick,
Aye.
Representative Feiler,
Excused?
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excused.
All right, committee, let's get back to work. House Bill 234. I understand the sponsor is not going to be with us this morning, and Representative Lean is going to present the bill. Welcome.
Thank you, Mr. Chairman. Yes, please excuse the primary sponsor and accept a co-sponsor in his place. Thank you, committee, for having me today. I am Representative Jamie Lean from House District 38, and today we have House Bill 234, Second Amendment Financial Privacy Act amendments. So this was passed in 2023, and we're just here to make a few amendments to it today to give it some penalties, civil and criminal, and to allow for a few definitions to be added to the legislation, and to make it so that the AG shall take care of some investigations instead of may take care of some investigations. So I'll get you started with page 1 just gives you an oversight that I just walked you through. Page 2, just at the bottom on line 21 where it starts to say, including any information derived from the financial records, the rest of that is pre-existing. Oh no, we're going to create 914-405. I apologize. And this is where the criminal actions come in, and then the definitions used to go with it. Some of the definitions are a financial record, and then 21 and 22 is where we're including any information derived from the financial records. On page 3, we're going to talk about firearm retailers, ammunition, antique firearms, a firearm definition, firearm accessory or components, and then there's several subsections to that carry over to page 4. And essentially, this is any component that is used to create a firearm or ammunition. So if you're going to be a reloading ammunition and you have black powder and casings, all of those things would be covered under this category. There's also a definition for merchant. And this is a person who possesses the ability to take payments for the purchase of goods and services related to a firearm. And then a payment card is listed on page 5, and the definition of that runs through, means a credit card, charge card, debit card, or any other card that is issued to an authorized user that allows the user to purchase goods or services from a firearm retailer or other merchant. And they renumbered the next section going through. And then there's a speak on page 5 about prohibitions of data being collected and what it's used for. At the bottom of page 5 on line 23, we add or any merchant category code versus, and then we're going to strike out subsection shall not apply to any financial institution that is not a merchant, servicer, or any record maintained in the ordinary courses of business of any financial institution or federal firearm license required by 18 USC 922. And instead, we're going to create the following language: that the state and political subdivisions are prohibited from using any personal or funds appropriated by the legislature or any other state funds to enforce, administer, or cooperate with any law, executive order, final rule, or regulations of the federal government that willfully keeps or causes to keep any list, record, or registry of privately owned firearms, or any list, record, or registry of the owners of those firearms created or maintained through the use of a firearm code or any other merchant code. This subsection shall not apply to any record maintained in the ordinary cause of business of any federal firearm licensee or as required in 18 USC 922. We want to make sure that we're not going to take away any of the FFL3 dealers that do provide firearms and the goods within our state, that we're not stepping on their toes to be able to maintain what records they need to keep for the federal government. So that section is really important. And then as you continue to move through the bill onto page 7, it speaks about a merchant code or any merchant located in Wyoming, and it distinguishes a merchant as a general merchandise retailer or sporting goods retailer. On the next section, D, gives us some discrimination laws that no merchant shall discriminate against a merchant owner located in Wyoming. Some ways that they could do that would be declining a lawful payment transaction, limiting or declining to do business with a firearm retailer or a customer for lawful transactions, or charging a higher transaction or intercharge fee to any merchant, or a customer for a lawful payment card transaction based solely on the assignment or non-assignment of firearm codes. It continues through there to the bottom to include firearm accessories, firearms components of ammunition. And the next section, as we move from page 7 to 8, talks about civil penalties and how those civil actions can change. And it changes that the Attorney General shall investigate alleged violations of this act on page 1, or line 1, page 8. And then it moves through, we strike out firearm accessories or ammunition merchant code and insert or any other merchant code that distinguishes a Wyoming merchant from a general merchandise retailer or a sporting goods retailer from any discriminatory practices as identified earlier. And then in the next section, it does the same to make sure that we're moving may to shall. And then as we move on to page 9, there's a new language created for those that live in Wyoming, how long you have to file for that penalty, or the investigation, I apologize. How long you have to file for it, what the Attorney General shall do with it. And then on to page 10, that continues. If the person knowingly and willfully violates or fails to comply with 30 days after being served the injunction, the Attorney General has all the wording on what should happen there. And then it just says the enactment clause of this state and the fiscal impact. There is not really any to be determined at this point by Wyoming agencies. A couple of reasons that this piece of legislation is really important is to make sure that we are not allowing for international banking policies to come into Wyoming and tell us how to do business, that we're protecting people's personal property rights and their ability to own firearms through the Second Amendment, that we are making sure that they're categorized very broadly as in something like sporting goods, and that we're making sure that we're not providing for additional workload to be on our banking industry by having to code out specific pieces of merchandise being purchased, and that we're not providing for retailers to have a coder in the background that is categorizing things individually as well. And with that, Chairman, I'll take any questions and hopefully I can answer them.
Any questions? Representative Shustak.
Thank you, Mr. Chairman. Representative Lean, thank you for bringing this bill to us. You started to, I was thinking all the way through your presentation, what problem is this trying to solve? I'm not quite sure what it is. You hinted at it towards the end when you said something about international banking law might have some impact on us. Can you describe in concrete terms what problem we're trying to solve and how this solves it?
Representative Lean.
Thank you, Mr. Chairman. Representative Chestik, we're trying to make sure that our individual personal property rights are not infringed upon by having a category of personal property that we purchase being categorized differently than, say, groceries or gasoline, so that we can't be tracked by any bigger entities, or that we're not going to put the small man out of business. If you happen to be an FFL3 dealer and you are a small individual firearms store, that if the international banking laws were to change and we were no longer able to purchase firearms, or that they would no longer be able to carry their funding through a certain bank because of the purchase of this equipment, that we want to make sure our small businesses are going to remain intact.
Representative Shustak, follow-up.
Thank you. Have you considered the possible impact on law enforcement for this? I can foresee situations where tracking the ownership of a particular gun used in a crime might be relevant to investigations. Would this impede law enforcement in doing its investigations of crimes?
Representative Lean.
Mr. Chairman, Representative Chestik, thank you for that question. I will refer you back to page 6, where it still says that we are not going to impose on any federal firearm licensee as required by U.S. Code 18922, where the FFL3 dealers will still have the ability to do their job that they need to for federal purposes, and this would not impose on that.
Follow-up?
Yeah, so I am not familiar with 18 section, USC section 922, but does that reverse everything that's going on in this bill? I assume that the bill has some purpose other than it's trying to protect some information. And if 18 USC 922 says all that information must be gathered to begin with, then why are we doing this bill? We're conflicting with federal law. I'm not sure what, the bill seems like it's trying to prevent the collection of information. And if we're not collecting relevant information that might be relevant to a law enforcement investigation, is this creating a problem for law enforcement? And again, I don't know what 922 does. If you could explain that for me, please.
Representative Ling.
Thank you, Mr. Chairman. Representative Chestick, for those individuals that choose to want to sell firearms, that is all the mandates through the federal government that they must they're required to maintain, that they have background checks in place, that they know the individual they're selling to. All of the things that the feds require for you to be able to purchase a firearm is that code. What this bill does is solves a local issue within our merchandising retail stores for those that are selling ammunition, firearms, concealed carry belts and the like, that they are not being categorized in a very specific manner within the store, that this is pushing it so that those categories become broad, something like sporting goods versus ammunition, or sporting goods versus handgun was sold.
Again, Representative Chestick.
Thank you, Mr. Chairman. I apologize for having so many questions, but I do have a lot of questions. You indicate on the fiscal note that there's no determinable impact to the judicial system or the Attorney General's office, and that's what it says, but that doesn't mean that it doesn't exist. It means that they just don't know how much it is. It seems like the bill does create some fiscal impact, especially on the Attorney General's office. Changing all those mays to shalls is basically telling the Attorney General what to do, how you must do your job, and we don't know how much work that's going to create, but it will create some work, and it's taking discretion away from the Attorney General, who may have other priorities. Have you had any conversation with the Attorney General's office about what impact this might possibly have on their work?
Representative Ling.
Mr. Chairman, Representative Chesick, I personally have not spoken to the AG's office about this particular legislation. That would be a phone a friend from our prime sponsor. If I get a chance to visit with him today, I'd be happy to come back to you and answer your question. I, as an individual reading this legislation, also understand that as cases arise, that will put a draw on our Attorney General and their staff. And I want them to know that we support them in what they're doing. And if that caseload was to get too heavy as we're approaching a budget session next year, I'd be happy to adjust their budget to cover any of those allocated expenses.
Representative Ling, I believe they had two positions stripped by our appropriators from their supplemental budget request this year. So that issue of may to shall concerns me. We have to be respectful of the workload on the executive agencies when we don't put in any appropriation in for personnel or time to attend to those. And so you might see an amendment from me on the budget bill relating to that.
Thank you, Mr. Chairman. I would just like to also say that the Attorney General's office should be working for the people of Wyoming, and we want to make sure that they are pushing back on any federal overreach and federal regulations. I understand at this time the Attorney General's office is at the discretion of the governor, and so we would be relying on him to be able to help us with that allocation of time to push back on these cases.
Yeah, and sometimes it's not a matter of willingness, it's a matter of logistics and reality of what you have for staff of the office to take care of things. And so I agree with you. We like them to be working for the people, but it's up to us to give them the resources to do that. Further questions? Representative Kelly.
Thank you, Mr. Chairman. My understanding is this is already in law, and what we're looking to do here is make it a little more prescriptive, put more teeth in it. One of the comments made was about international banking policies. And I'm wondering, considering some of these international banks have market cap's 10, 20 times the size of the economy of Wyoming. Is there any concern that these banks might just decide to pull out of the state and deal with this?
Representative Lean.
Thank you, Mr. Chairman. Thank you, Representative Kelly. I have not spoken to the banking industry on this, and so that's a great question. I'd be happy to follow up and get back to you.
Okay. So I know that someone from the banking industry is with us today who also has a bill pending right next door. So I'm going to let Mr. Meyer come forward and comment. Please introduce yourself for the committee and tell us what you want us to know about this bill.
Thank you, Mr. Chairman. Members of the committee, Scott Meyer on behalf of the Wyoming Bankers Association. The bill next door is taken care of, so I can answer any questions you might need. I think Representative Kelly's right. This is trying to be a little bit more prescriptive, but here's some information that you don't know, and I think try to answer some of the questions that Representative Chestic had as well. I did look at that federal statute. It deals with firearms. I didn't have a chance to go through a lot of it. I don't know that it really has much bearing on what they're trying to do here, but I do think it's worthwhile to make sure that we know that law enforcement has that information that they need, and I think that does provide that. I think that there's a couple things here that I'm concerned about. The discussion about the merchant category codes. And we've had this discussion before for the legislature, but understand that the merchant category codes are not set by banks, they're not set by credit card companies, they're not set by merchants, they're not set by anybody like that. They're set by the International Organization of Standardization, which is purely voluntary. So our merchants here don't have any choice of what has been assigned to them. And I don't see anybody in the room that represents the merchants, but they really don't have any choice in that, and neither do the banks. And the banks don't even get any of that kind of information. And whoever does get it, I guess, from companies like Visa, MasterCard, American Express, they put those things in there. Generally, those are to make sure that they assign the awards. So if you get 3% back because you took a flight and you booked your flight food, they give you that. That's where that 3% comes in because they know that's what that code is. And I think a couple of them say, this month we're going to make sure that you get an extra bonus rewards points if you eat out and you go to restaurants. That's what those codes do. I don't know that you can actually use those to track anything. So to the extent that the bill does require that these merchants not new, I don't know how much they can have any choice in the matter, but I think it's kind of benign because it is what it is, and they're not the ones that are choosing this either. So they're not singling out anybody, and whatever credit cards they're using, they're using. So I get kind of concerned with some of that language because I'm not sure it does anything. I think the question that I think Representative Kelly talked a little bit about international banking, that is interesting, whether any of these large companies would cease to do business. We had a bill similar to this about 3 or 4 years ago regarding firearms and whether they could use credit cards. And that particular company, which, by the way, is not a member of my association, does not have any business going on in Wyoming as far as locale, but they are one of the largest credit card processors. They put a rule down that they would not allow their processing to do firearms. Okay? That doesn't affect me if I have that card from that company to go in and use that card to go buy ammunition, but the retailer that had that card said, or they had that reader, that processor, was prohibited using it for firearms. There was enough blowback on that they finally backed off, but the reality is that particular credit card company, processing company, does 90% of the work in Wyoming. So if they had the notion to, they could pull out. And that would put us in a heck of a bind because there's not anybody else right now that's able to pick that up. Thank good public policy pushed on them a little bit and they changed their mind. So hopefully that answers a few questions about how some of this stuff is working. With respect to the bill itself, I've got a couple things that I want to point out to the group. When you look at it, and I think it's page 8, when we talk about there's also some civil penalties that are on here. I agree with the comments that were made about regarding the Attorney General and the shall. We've had some of that stuff with other bills where you look at it and you say, you didn't even allocate any money here. This could cost very minimal, or it could cost millions. I have no idea, and I think that's where appropriations is having problems with it as well. I don't know how you book this, but if you look on page, I said 8, I meant 9, there's a civil provision in there, and it starts on line 9, that if the Attorney General does not. Well, if you got some shells in there, I'm not sure what we're gonna have if not, but this is what we ran into on that bill that I talked to you about before regarding the firearms. When you put in a provision like this that says if the Attorney General does do this and you can have a civil action, this is legalized extortion. Because what the people do, well, they'll come in and say, we're going to challenge this and we don't think you're there and the Attorney General hasn't done anything, so we're going to file suit. And I can tell you from the banking industry, when you get a lawsuit like this, all of a sudden it's easier to pay them the $15,000 or $20,000 they're asking for before they hire a lawyer and go through all this stuff. I would recommend, and I suggest that from on line 9, from where it says if the, and then go down to the end of the next, I guess the sentence on 16, but strike that. I would take out that civil action option. Because like I said, that really has become, as we've noticed in the banking industry, just legalized extortion. Other than that, I understand what the bill is, and from a personal standpoint, I don't want anybody tracking my stuff either. I'm just not sure what it does to fix all this stuff, but if they want to put some teeth in it, that's fine. But again, merchants don't have access to those codes. They don't change those codes. They don't keep track of that stuff. It all runs through the processor, and they are the ones that can elect to do that or not. So with that, Mr. Chairman, I'd stand for any questions.
So thank you for being here this morning, Mr. Marr. So you mentioned that these codes were set by an international organization and that they were completely voluntary.
Yes.
Voluntary for whom? It sounds like the retailers don't have any discretion, that it's set for them by others, or how's it voluntary? Explain that for me.
Yes, Mr. Chairman, that's a good question. What I meant by voluntary is that's what the credit card processing companies who pick up those codes can use them. They're not required to do that. They don't even have to use the merchant category codes. The reason, like I said, is for awards and those kind of things that they track. Those codes can also be used to dictate, if we know what's going on with a particular code, how much they're going to charge the merchant, whether it's 2%, 3%, 5%, those codes help do that. But that's only for their purpose, and they can use it or they don't have to use it. It's not required by law. So when I say it's up to them, it's not required by law that you use these standards. They just choose to use those standards. Yes, sir.
Further questions for Mr. Marr? Seeing none. Thank you again. I'm glad you were able to join us.
Yeah. Thank you for your consideration, sir.
Others in the room wishing to testify on this bill? Mr. Jones? Please identify yourself for the record and tell us what we need to know about this bill.
Mr. Chairman, thank you, and committee. My name is Mark Jones. I am a national director with Gun Owners of America. I live here in Johnson County, Wyoming. We support this bill. The Representative Lean did a great job of explaining it, especially for someone who was handed this, at the last minute. Some of the information that's been put out has been a little bit misleading. I spoke to the Sheriff's Association before this meeting. The reason they're not here is there is no impact on law enforcement at all in the state of Wyoming. This changes nothing about the way anything related to crimes with firearms are handled. This is entirely an issue with banking and tracking of firearms purchases. There was a law passed a year or two ago in Wyoming that made this illegal, and this clears up and improves a lot of the language related to that.
The insidious part of this is that this international standards organization, and you can go read about this for yourself, it was very widely publicized. When they came out with this concept, it was part of ESG, environmental, social, and governance scoring. And it's a way, the first step of this is designed to identify who's selling firearms so they can debank them. The first step of this is not about tracking when I buy a firearm. That's the second step. That's coming next. Okay, so let's make sure we understand that. And the Biden administration pushed this very hard on the American banking system and the credit card companies. And states stepped up around the country and started passing these laws to stop it. And now that the Trump administration's in place, some of the banks and credit card companies are trying to back off a little bit because, you know, they kind of see the handwriting on the wall. But we need to get protections in place against this. This is step one. It's designed to debank those who sell firearms. And here's how it works, and most people don't understand this. They get to assign a code, and let's say it's Mark Jones's gun shop, and I get 80% of my money from guns. They give me a firearms merchant code, and everything I purchase is coded under that. And Walmart, who may only get 1% of its money from firearms, doesn't even get a firearms merchant code. It's designed to eliminate, it's designed to identify and then debank the small firearms companies. The second step, if we get another Democrat president, will be to track the individual purchase so they can identify the individual, create a registry. As the good representative of the bank said, this is voluntary. So why, there is no reason any entity should want to implement this in the state of Wyoming. Why do they want to track our firearms purchases? And regarding the penalties, there was, I think, a little bit of hyperbole about the effect of these civil penalties. The laws, this bill would specifically require a long, arduous process to get to the civil lawsuit. And if you go to 9-14-404D, there's a long process that's laid out there where the Attorney General would have to investigate. There would have to be a waiting period before there's any lawsuit. You can't go file a frivolous lawsuit. You have to have, the Attorney General has to not act. Then you've got to hire your own attorney, go in front of an appointed judge. So there's not going to be this, it's not like they're going to start suing everybody. It's not going to happen. This is a deterrent. The simple thing is, don't track our firearms purchases. Nobody has to worry about it. I have yet to see anybody come from any financial entity and tell us why they want to be able to track firearms purchases. If you're not going to do it, then you don't have to worry about the penalties here. So this is a good bill. It clears up some things that are already in statute. It provides a lot of definitions that need to be defined. I disagree with the idea that we shouldn't have strong language in here that says the Attorney General shall enforce it. If there's not enough staff, let's give the Attorney General more staff. We'll support that. But we should enforce our laws. We should protect these businesses. We should take a stand now against the tracking of firearms purchases. And I think it's hyperbole to suggest there's going to be this widespread lawsuits over this, because what will happen is what's happened in other states is they just don't assign the codes. Because the real thing is, this is an ESG initiative designed to identify and punish people involved in the firearms business. And if you put a law in place, they won't assign them here. A couple other points. What this would do, it would require them to code these as either general transactions or sporting goods purchases. You go in, they don't know if you bought a tent or a gun, okay? That's the way it used to be. So this is a common sense bill. It's not, the sky's not gonna fall. Banks are not gonna pull out of Wyoming. The Trump administration is going to push back against this hard anyway. They're going to push back against the banks doing this. We'll see this die off for a little while probably, but we should put some provisions in place in Wyoming to protect ourselves now. Thank you.
So, Mr. Jones, so who would the Wyoming citizen sue? But it sounds like these codes are set by a voluntary acceptance by the credit card company. So if my credit card company has agreed to use these codes, and and I use their credit card and they're tracking my purchases, one, is it the retailer who files the suit? Is it the purchaser who files the suit? And who are they suing? Am I suing Mark's Gun Shop?
Well, and no, you wouldn't be suing Mark's Gun Shop if the credit card provider was the one that forced it on the gun shop, because the gun shop had no choice. You would force the financial entity that was responsible for forcing the code. Everybody says they don't need it. They say they don't want to track our purchases. Well, then don't force the code. You would sue whoever forces the code into the state of Wyoming. And that's going to be an arduous process, Chairman. It's not going to be easy. There's not going to be a plethora of lawsuits. You're going to have standing, hire an attorney, and spend a lot of money. There's going to have to be an egregious violation. What will happen is they won't assign the codes here. That's what will happen. And that's what's happened in other states where they've passed these types of laws. They don't assign the code. Because what everybody knows, the dirty little secret about all this is nothing but an ESG initiative to track and punish those who sell firearms.
So who is they?
The International Standards Group, they wrote about this 4 or 5 years ago when they first came out with this. This was an effort by international interests to impact the firearms industry in the United States. And they were very clear about it. In the early stages of the Biden administration, there was a climate of anti-gun, anti-firearm, and they were very clear. It's been written about prolifically. Now, again, they're backing off in the current political climate, but the clear goal was to hurt firearms stores. And the way it was designed, again, I described it earlier, it doesn't work exactly like people think. Walmart won't get a code. Scheels won't get a code because they have a small percentage of their revenue from firearms. But Mark's Gun Shop will get one. They'll identify who I am. They'll use that against me through the ESG process, debanking, credit, things like that. That was the goal of all this. The first stage was really that. The second step, if we allow this to go, will be to track the individual purchase so they can identify, Chairman, that you buy a gun or that I buy a gun.
Representative Kelly.
Thank you, Mr. Chairman. It was mentioned a couple times about other states passing similar legislation. I have not done as much research on this issue, so perhaps you could fill us in further on which states, what the effects have been, and has there been an increase in civil litigation due to them?
Mr. Jones.
Mr. Chairman and Representative Kelly, thank you for that question. Yes, I think last year, the National Shooting Sports Foundation was here. This is the third or fourth year that this bill has come before the legislature. And they testified then that there were like 16 states that adopted this legislation as of last year. And I think there have been more since then. I don't know what the total number is now. And I have not heard of any lawsuits. What I have heard from both the National Shooting Sports Foundation and members of Congress is that actually these international entities are backing off because the states are passing these laws. And because, and they were backing off before Trump was elected. That's also going to cause them to back off. It doesn't mean we shouldn't pass a law. It doesn't mean we shouldn't take preemptive steps. But the state laws that have been passed have forced a lot of these companies to back off of establishing these codes. That is the word around the country.
So, Mr. Jones, after we passed the statute last year, they back off in Wyoming?
Well, we don't really know. I mean, we may walk out of
How
here.
will we know if we pass this law whether it's had any effect?
Well, if they don't start doing it, we'll know it worked. But, this is a good law. It's a law that's in line with the law of many other states. And again, if they don't have any nefarious intentions, why do they want to establish these codes? They have yet to step up and give a good reason why they want to single out one entity for selling firearms over another. Why are they not singling out tents or canoes? We all know the answer to that, right? They're not singling out anything else but firearms.
And I don't dispute that, but what I'm getting at is if we already passed the law and these state laws will force these international groups to stop doing this, how will we know when they stop doing it? Did they stop doing it after we passed the law last year? And you said, we don't know.
Well, Mr. Chairman, respectfully, our law has been the one that was passed last year was the weakest of all the 16 laws I looked at in America because it has no enforcement mechanism. It says the Attorney General may So it is widely regarded as the weakest of the 16 that I looked at. The laws in our neighboring states are much better. So, we have a very weak show law in the state of Wyoming. Other states have stepped up and actually took a strong stand. And again, we're seeing the banks back off.
So you can say that in those states that pass stronger laws, these international groups no longer require the codes in those states?
Yes, I definitely have been told by every source I have that they are not doing this in the states that have passed the good laws.
Okay. Further questions? Representative Brady?
Thank you, Chairman. Mr. Jones, I have several questions, so maybe I can do some follow-up so I don't forget what I want to say. Talk about ESG, International Standards Group, and as the prior speaker spoke, it's all voluntary. Can you tell us how this word voluntary, what happens if they don't volunteer? And voluntary, in my opinion, is that if they don't volunteer, then, for example, the credit cards don't have access to finances. If the businesses don't volunteer, then they could lose their business, from what I'm hearing about other testimony. And so let's start with that and tell us what happens to credit card companies and businesses when they don't volunteer.
Mr. Jones?
Mr. Chairman, Representative Brady, I have heard of no instances where any business has been negatively impacted in the states that have passed the good laws. What the international entities and the credit card companies have backed off of trying to push the firearm code. I have heard of no instance where this was pushed to the point where anybody lost their business or was any way affected. The credit card companies are backing off.
Okay, and follow-up, may I?
Follow up?
Mr. Chairman. So what I'm thinking of is for the government or anyone to flat out try to impose a ban on the Second Amendment or repeal the Second Amendment, that perhaps they're using the banking industries and for such to do a backdoor to threaten and control and monitor and the sales of guns and such, ammunition.
Mr. Jones?
Yeah, Mr. Chairman and Representative Brady, absolutely. That is the intent of this. And again, the international groups that initially pushed this wrote very clearly what their intent was. It was part of ESG. It was part of an effort to demonize and debank firearms industry in the United States. It was step one in a bigger step. If we had a Democrat president and this was widely implemented in the United States, the second step would be to track the individual purchase. The first step is what I've been describing. The second step is the individual purchase. And they were very clear about what they wanted to do when they came out with this concept a number of years ago. So yes, it's a backdoor way to debank, definance firearms sellers, and then later, you'll get it, if they have their way, you'll only be able to buy a firearm at a place like Walmart or Scheels, the big places. And eventually they'll have registration and confiscation. That's the ultimate goal, if they can take it to its logical conclusion.
Mr. Jones, in the states that don't have any of these laws, have there been firearms retailers who have been debanked?
I think that in the states that don't have these laws, the retailers have been going along, at least as of last year when we had testimony here. We had a lot more testimony here last year. We had National Shooting Sports Foundation, other groups were testifying with experiences in different states. And there were some states like California that were implementing this, no surprise. Other states were pushing back, like Utah and Idaho and hopefully Wyoming. And my understanding is that the more states that push back, the more the companies are likely to drop trying to push this in the United States, because it becomes too complicated for them to have a policy. If they can't do it in 16 states, and hopefully Wyoming gets a better law, this law. At some point, it becomes too confusing for these companies to try to implement a different policy in California that they're doing in other states, and they'll hope, and again, the Trump administration is going to push back too. And hopefully we stop them from doing this. If 16, 17, 18, 19, if we grow the number of states pushing back, it's possible they'll drop it in all the states. But I can't tell you for sure what they'll do, sir.
Any further? Thank you, Mr. Jones. Appreciate you being here. as well.
Mr. Chairman, thank you. Committee, thank you very much.
Anyone else in the room wishing to testify on this bill? 234. State your name for the record and tell us what you want us to hear.
All right, good morning, Mr. Chairman, members of the committee. Mark Moody. Yes, I am a member of the Cheyenne City Council Ward 3. However, I'm speaking just on behalf of myself and as a life member of Gun Owners of America and a life member of the NRA. I support this 100%. I testify in favor of it, last year and the year before. I do like the fact it talks about firearm accessories because that was my concern. It was added. And I like the fact it details what those firearm accessories are, so that way they're not tracked. And I'll stand for questions.
Questions for the witness? Thank you for coming, sir.
Thank you, Mr. Chairman.
Anyone else in the room wishing to testify? Anybody on Zoom? Oh. A follow-up for Mr. Meyer?
Mr. Meyer, yes, I'd like to ask, Mr. Chairman, I'd like to request Mr. Meyer come back.
Recall the witness. Representative Bratton.
Thank you, Mr. Chairman. I'd like to ask Mr. Meyer, I'm concerned about the position this is putting our Wyoming banks in. Seems like they're kind of being caught in the crossfire here, if I may. And I want to know if you could speak to any impact that has happened to banks in the states where this has passed, and what you see is, how this is potentially, what you think about how this could potentially impact our banks here in Wyoming. Thank you.
Mr. Meyer.
Mr. Chairman, Representative Bratton, I think that the best way to summarize this is to understand that as I mentioned, these are voluntary codes for the credit card companies. And make sure that we talk a little bit about the credit card companies, those, as maybe the testimony that you heard before about these financial institutions. The credit card companies aren't necessarily the financial institutions. They are credit card processing. That's where they make their money. They're the ones that put codes on. I think that the answer to your question, Representative Bratton, is that it has not a lot of impact on us because we don't have anything to do with that. We don't assign the codes. We don't look at the codes. We don't know what the codes are. We don't know. We don't get a report. All we know is that money went out of somebody's account and money came in when they got paid or whatever, and things are taken care of, but we don't have any impact on that. We could even have credit cards that says ABC Bank, and it's a Visa card. That's because we make a contract with Visa to say, we'd like to have a card in our name, and that's really cool, and everybody uses it, but we don't get any reports from it. We might get a small percentage of a fee with them, like 0.5% or something, because we get to use our name, and that is really big in Wyoming. But we have nothing to do with the codes or the sales or anything else like that. So in answer to your question, I don't believe that this has any impact on Wyoming banks other than people thinking that they have a right to sue the bank. And I will add, Mr. Chairman, the comment about, I'll take a little bit of exception, but the comment about, don't worry, there's these people that want to file lawsuits, they still have to hire lawyers and they go through this. No, that's what they don't do. They threaten. And then you look at it and you go, okay, maybe we'll just give them some money and tell them to go away. So that's where I say it's legalized extortion. That's just what happens.
Thank you. Further questions? All right, thank you. Appreciate you being here.
Mr. Chairman?
All right, with that, I'm going to close public testimony, public comment. Representative Lean, I'll give you one chance to finalize your argument for the bill. Anything? All right, committee, what's your pleasure? Move the bill by Webb, second by Brady. Discussion on the bill or amendments? Representative Chestic?
Thank you, Mr. Chairman. I'd like to move an amendment on page 9 to address the last comment from the banking interest. I do believe that strike suits are real. As a lawyer, I've dealt with them. You file a suit you know has very little merit, but you try and extort a settlement. That does happen. I've seen it happen. So for that reason, I would like to amend the bill by striking the sentence that starts on line 9 and ends on on line 16 that creates this private cause of action. I would like to strike that sentence.
I'll second that. Do you have the amendment, Pia?
Yes.
All right, discussion on the amendment. Representative Chestic.
As I said, I think it's these kinds of legal extortion happen, and they don't necessarily need to hire a lawyer. They can act pro se. That happens a lot. I've seen that happen before. So I do believe this creates the risk of legalized extortion is a good term. I think it actually is the risk. Frivolous lawsuits do happen, and like I said, you don't need a lawyer to file a frivolous lawsuit. I've defended many pro se cases, so I just think that this is opening a door for temptation and it creates a risk to the banks, and I therefore support the amendment.
In addition to that, I think with the language saying shall, the Attorney General shall, then, you know, this is contingent on the Attorney General not doing those things, and we're telling the Attorney General shall do these things. So I think having this language in there doesn't strengthen the bill, and it does put our community banks at some risk. And so for that, I'll support the amendment. Further discussion, Representative Brady.
I'd like to say on the discussion about frivolous lawsuits regarding this amendment that Representative put in. Frivolous lawsuits, if those happen to come about, is not at the risk of my Second Amendment right and how I want to do my banking. But so I'm against that amendment. But and I think removing shall just weakens the bill. It just takes everything completely out. That's the reason it's here.
Further comment? Representative Kelly?
Thank you, Mr. Chairman. At this point, I'm going to be a no on the amendment. I think that this requires a little more research, a little more discussion, and I'd rather see this in the committee of the whole, maybe second reading amendment. I have more to learn before I make a decision on that, so I'm going to say no for now.
Representative Webb?
And Mr. Chairman, thank you, and I agree with Representative Kelly. I think we need more information from the Attorney General's office specifically to find out the impact that this may have on them.
You know, that's, you know, kind of incumbent upon the sponsor of the bill to obtain information from the agencies and so forth when you're going to bring these types of bills before us. And so that's why I'm going to support the amendment. But further comment on the amendment, Representative Lee.
Thank you, Mr. Chairman. I do believe that the sponsor has spoken to the AG's office, the prime sponsor, but I myself did not get that information and I did not speak to them myself. And so I will reach out to the primary sponsor and I'll get back to the committee with that information.
Okay. Committee, all those in favor of Representative Chestic's motion to extract the personal cause of action language on page 9, say aye. Aye. Those opposed, no.
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 That amendment has failed. Further amendments to the bill. Representative Singh.
Thank you, Mr. Chairman. On line 10, starting on line 10, the very last word, 60, and continuing to 11.
Still on page 9.
Yes, on page 9. Continuing on to just the 60 days into line 11. I'd like to replace that with 180 days.
Is there a second? Second by Chestic. Discussion on the amendment, Representative Singh.
Thank you, Mr. Chairman. So I am bringing that from the Wyoming Rules of Criminal Procedure, their definition of a speedy trial. I know that's not necessarily applicable per se, but this is the definition that we use for something that's speedy. And so just giving the Attorney General some additional leeway to come to a decision or to create an action there.
Further discussion, Representative Justic.
I seconded the amendment, and I'll vote for it because it makes this section a little less bad. I'm still not in favor of the bill, but I think this is ameliorates some of the worst parts of that section, so I will support the amendment.
I'm still a little unclear on how the Attorney General even knows this private cause of action has occurred. So I suppose the person who believes that they're being tracked with the number for purchase is responsible for notifying the Attorney General that they believe that their credit card company has tracked them. I'm not sure how the purchaser would know that, whether or not their credit card company is one of the credit card companies that track these purchases. It sounds like this takes place in a way that not exactly transparent for the credit card holder. So I believe that would be the action, that the shopper would believe that they're being tracked and would then file some claim with the Attorney General's office. The Attorney General's office with this amendment would then have 180 days to respond to that, and that's just the Wyoming shopper. That's your understanding?
Yes.
Very good. All right, further discussion? Representative Brady?
Thank you, Chairman. I, at this point, don't see, I'm going to be against this amendment as well. I'm not convinced that increasing the days, this is imperative, I think, and it should be addressed quickly rather than give it more time. Thank you.
It just seems to me that in the grand scheme of things, when you think about all the litigation, all the issues that come before our Attorney General's office, this may not rise to the top of the pile at any given moment, right? You've got coal litigation, you've got this litigation, you got all these other things going on. And I think giving 180 days is a reasonable turnaround for the Attorney General's office. Representative Brady?
Thank you, Chairman. And it may, I'm just saying, in my opinion, I'm going to vote against this because it can be, all these, whoever brings forth something before the Attorney General, I don't see a reason why it needs to be extended. And we'll make sure that our intention should be to make sure the Attorney General's office is equipped to handle anything within, whatever days whatever law says to file within.
Okay.
So I'm just against it. Thank you.
Further discussion? Representative Lean?
Chairman, for the bringer of the amendment, you mentioned the Wyoming Rules Criminal Procedure Book. Does 180 days conform this law to existing law?
Vice Chairman?
Thank you, Mr. Chairman. So 180 days is coming from Rule 48B for the definition of a speedy trial in the rule in criminal procedures in the state of Wyoming.
Representative Chesky?
Thank you, Mr. Chairman. There's no reason why this law has to conform with the speedy trial rule. They're different concepts. This is a civil action. That's a speedy trial is a criminal case. There's really no need to tie them together. I'm in support of the amendment because it's better than 60 days, but there's no need to have them conform.
All right, everybody clear on the amendment? We're changing 60 days to 180 days. All those in favor say aye.
Aye.
Aye. Those opposed?
No.
Let's have a show of hands. And all those in favor, raise your hand. 1, 2, 3, 4. All those opposed, raise your hand. 1, 2, 3, 4. It's a tie. I think the tie fails. All right, further amendments? Seeing none, comments on the bill? Representative Kelly.
Thank you, Mr. Chairman. Through the magic of current technology, I was able to do some on-the-fly research about other states having done this. What I'm seeing here is, as described by an earlier witness, more of a political battlefield. And the states that have enacted such laws is a who's who of the red electoral map. On the flip side, there have been states from the blue territories, the larger ones, who have gone the exact opposite route and passed laws mandating tracking of firearm purchases. So I've not seen any issues across the board, whether for or against such tracking, with out-of-control litigation with law enforcement. It almost seems in some ways like a political football, but I understand pushing back on this tracking idea. I'm in favor of the bill. I understand that there's some work and some polish, and I believe the sponsor of the bill was coughing worse than me yesterday, might be why he's not here. So I'd like to advance this, but, and polish it further.
Representative Jestick.
Thank you, Mr. Chairman. I will be a no on this. Number of reasons. One big reason, this is an unfunded mandate. Didn't think we liked unfunded mandates, but this is an unfunded mandate to the Attorney General's office. And I just don't see the need for it. This is a voluntary program that I don't see the risks that these, the merchant codes can be used to provide benefits to credit card owners for purchases that they get points for. So I just don't see the need for it.
Further discussion? Yeah, I'm kind of a mixed mind on this bill. I voted for the bill last year, and I think the one year before that, and I'm just, unless credit card companies make it a point to let us know what codes are being used, where and how, I'm not sure the average shopper knows one way or the other whether we're being tracked when we use our credit cards. But I'm going to vote for the bill today. We'll see what amendments come forward on the floor, but I am very concerned about the staffing requirements at the Attorney General's office, given our budget bill. And I think there's a limit to what we can ask agencies to do without ponying up the resources. And I appreciate Mr. Jones' testimony that he would endorse the idea of giving the Attorney General the resources necessary to fulfill this important responsibility. So I'll be an aye vote today. With that, call the roll.
Representative Brady,
Aye.
Representative Brett,
Aye.
Representative Chestek,
No.
Representative Filer,
Excused.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washat.
Aye.
7 ayes, 1 no, 1 excused.
Representative Lean, if Representative Alaman is not back, you'll have this on the floor. That concludes our business for House Judiciary on this Friday, and hopefully we all get a weekend off and people get healthy. So we'll see you back here on Monday morning at 8 o'clock.